Nuisance. The first few slides are about nuisance cases. Nuisance is not an area of DNR regulation. It is when one individual or more decides and believes that something else, in most cases what we're talking about here, livestock operations, hog operations, are unreasonably interfering with the use and enjoyment of their property. Do I sound like a lawyer there? That's what the law says. If it's significantly interfering with the use and enjoyment of their property, that person or persons can file a nuisance lawsuit. Normally it's over odor, also flies, some other factors come into play, but odor is the primary issue that we see the subject of nuisance lawsuits. Before I talk about those lawsuits, I always like to talk about what you hopefully can do to avoid one. This list hasn't changed much over the years, but yet I think it does bear taking a look at. I'll start by saying you can do everything I have on this list as a producer, and in one spot, you'll be fine. In another spot, you could get sued, and you could say, but McAfee, I did all that, and I still got sued. Sometimes it just, how can I say this? It just depends on who you live by. And all you can do is control the factors you have control over. And one thing I deal with producers who are the subject of a nuisance lawsuit, they feel, my gosh, what did I do wrong? And again, I don't want to dwell on this too much, but sometimes you're playing bad luck to be in the wrong place. And that's something you have to evaluate if you're citing a new operation or after you're there and dealing with this. You just have to take a look at the best you can do to operate your hog operation as responsibly as possible. Okay? Overall, operational environmental management, including neighbor communication and relations. Rita Cook is here with the Coalition to Support Iowa's Farmers. They do a great job on behalf of the commodity organizations who are members of that coalition, including the Iowa Pork Producers Association and other organizations. They do a great job of working with producers on neighbor relations, citing that operation, etc. So please feel free to use the coalition. They're a great resource. What am I talking about there? Overall operational environmental management, just the whole system. And I know that's a little vague, but just take a look at your whole system. What is that? It's the buildings. It's the ventilation. It's the manure application. It's mortality disposal. It's all of those things. And communicating with your neighbors so they know what you're doing. You have to make that decision how much of that you want to do, but I think that goes a long ways towards making neighbors more comfortable with your hog operation. Location, 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 the second bullet point there. And sometimes there's no substitute for that. We all know that the further away, looking at prevailing wind patterns, etc., that's the place to start. But if you don't have that, there are other factors you can use to overcome some of the location factors, depending, again, on your individual location and who your neighbors are. Tree buffers, I think we've talked about that many times in past years, and we continue to take a look at the science shows tree buffers help with dispersal of odor through the wind patterns, etc. And I'm a big believer in a fast-growing species that gets up there 20 to 30 foot tall within a few years, and then have slower-growing species planted along with that. Again, the coalition has a great program that they work with the commodity organizations on tree buffers. Ventilation and exhaust fan management. You spend a lot of money in your hog buildings to have proper ventilation. And some on the other side of that V, if there's a lawsuit, would say that's just for pig comfort. You spend money to keep those pigs comfortable, but you don't do a darn thing for the neighbors. They're wrong. What you do for pig comfort also is of benefit to you and anyone else who lives around those hog buildings, in that you know if that pig is comfortable, if that pig is clean, then the manure is in the pit. not on the pig. And the research has shown that is a big, big factor in odor control. So don't sell yourself short or let anyone else sell you short on the money and effort you put into proper ventilation and management of those buildings. And that is a key factor in taking a look at your operational management. Management of the manure storage and application, pit additives, it's something that you all need to take a look at. I'm not selling anything here, but take a look at pit additives. They have benefits in some cases, and in others it may not work out for you, but at least take a look at it. Application, injection, etc., notifying neighbors before you apply. Again, these are all part of the overall management. And I've already talked about clean pigs and buildings. Mortality handling. If you compost, please take a close look at the regulations as far as the amount of bulking agent, etc. Again, we have details in the slides, more details in the handouts. It is absolutely critical that you properly manage that composting facility. What happens if you're in a nuisance lawsuit? The perception can be to the jury or anyone else in your neighborhood, even if you're not in a nuisance lawsuit, if you compost, what's going on there? Pigs are being placed in a facility and allowed to compost. That compost is done properly. It is practically odor-free. But what's the perception? There's a dead pig in there that's rotting. Okay? That's the perception. We know if we do it right, just like I just said, it's a great process. It's a great way to return that mortality to a nutrient, something that can be used. So again, you can overcome that perception. It's just something we need to work hard at, both with DNR and inspections, and if you happen to find yourself subject to some concerns from neighbors. Slide 3, protection for the producer. What can we do? Well, again, I'm not selling anything, but there is insurance. Many of you know this. We'll start with the standard farm liability policy that you all have. Does it cover nuisance? And I'm talking just a standard farm liability policy without any special endorsements. Normally it does not, but you should always check. Check when you're putting your buildings up if you have a concern about possible concerns from neighbors. And for sure, check if you receive a mediation notice that someone plans on filing a nuisance lawsuit against you. Never just think, okay, I'm not covered, I'm not going to even check. Check. Here's what many of you have heard about some cases from other states. We had a case a year ago that I mentioned at Port Congress where, again, I'm talking about standard farm liability policies where you don't have a special rider. In Illinois, the court, well, what often happens is those farm liability policies have a pollution exclusion, and that pollution exclusion, the companies will say, because of that exclusion, you don't have coverage for nuisance because odor is a pollutant, okay? That's what some companies will tell you, all right? In Illinois, the Illinois Supreme Court in 2013 found that odor from hog manure was not a traditional environmental pollution, and therefore the pollution exclusion did not exclude coverage under that policy. I'll talk a little bit more about that in a minute, but a good decision for producers. Then along came a decision in Wisconsin that same year. Now, don't look at the slide yet. You'll all look when I say that, right? But in 2013, a court in Wisconsin, an appeals court, number 2 up the ladder, said the same thing, that manure was not a traditional pollutant. Said it a little differently, and ruled that the pollution exclusion did not exclude coverage. Well, it went on up to the Wisconsin Supreme Court, and they just ruled at the end of 2014 that, and I'll look right at the slide, that manure that polluted a well, so we're not talking in that case, the allegations weren't odor, they were water pollution, that someone's manure got in someone else's well. The Supreme Court said it is a pollutant when it gets into the well, and there's no coverage because of the pollution exclusion. Now, I've seen quite a bit on the internet about this case, concern for producers, and I would share that concern, but I think we need to put it in context. Number one, that producer evidently didn't have the special environmental coverage I'm going to talk about in a minute. And two, the situation was a bit different in that the allegation anyway is that the manure got into the well. Different than the Illinois case, different than what we deal with, what I normally deal with in nuisance cases. Over the years, in the nuisance cases I've handled, while the people suing will initially talk about concerns about water pollution, etc., I've never had a case actually go to trial, or at least get even very far down the road that it involved water pollution. It always is odor. And so therefore, this Wisconsin case, while I wish the court would have ruled the other way, I don't think is not anything that will cause great concern for a lot of insurance policies for odor nuisance lawsuits, and especially slide 4, if you have special environmental coverage and endorsement, etc. For those of you that have come in later, not to point, we do have handouts in the back. Be sure to grab one on your way in. If you don't, someone will grab one for you. Glad you could make it. All right. Environmental policies are available. If insurance is one of those things, you don't want to buy it unless you need it, right? But by the time you know you really need it, it's often too late. Okay? So, and again, I'm not selling it, but the time to get it is before you really know you need it. So you've got to make that decision, because if you're putting up a hog building and you get a letter from concerned neighbors, either from themselves or an attorney, you then fill out an application for an environmental policy, and you have to truthfully answer the questions in those applications. If it asks if you've received any such communication, chances are you won't get coverage. So my point is, folks, you need to be checking into that early on when you're putting up a building, not after you know you've got some neighbors that are concerned. Okay? You need to make sure, and the third bullet point down there, insurance is a contract. Let me back up. What does it do? It covers if you are sued and there is a judgment against you. It will cover up to policy limits the money judgment, not so to speak, the money judgment. And there is normally coverage for legal costs of defense. People like me, if you have the coverage, it'll pay for someone to defend you. The insurance company will retain an attorney on your behalf, and you will be defended. And in a lot of cases, that even if you win, people like me don't come. I'm pretty cheap, but the rest all charge too much. So it is a big part. I've seen producers that I've represented who didn't have environmental coverage. Even if they come out ahead, it's a huge strain on their operation for the legal costs of defense. So I'm just suggesting you take a look at that and make sure the policy covers it. It's a contract. Carefully, and I underlined that, carefully review the policy terms to make sure there is coverage for odor nuisance claims. Now, as an attorney, everything I write, everything I put out is so clear and so easy to understand. I don't understand how they write policies that aren't much more clear than what I write, okay? All right, my tongue is out of my cheek now. All right, and I can, I'm sure I'm going to make somebody a little irritated by saying that, but that's all right. I can read those environmental policies, and I can read them and read them and read them, and if you look in there, the ones I've reviewed anyway, you will not find the word nuisance in there anywhere. You will find and you probably may not even find odor. You will find gaseous emissions. You will find words similar to that. There are companies that offer policies that do cover odor nuisance claims. And they cover claims by neighbors that say it's impacting the use and enjoyment of my property. Is it causing me bodily injury? No. Is it causing me property damage other than reducing the value of my property? No. You need to make sure your policy covers those kind of claims. And there are policies that do that. Quite honestly, there are environmental policies out there that don't cover odor nuisance claims for the type of claim I talked about, where people say it's just, I can't sit out on my deck at night, or I can't, have friends over. It's not necessarily a bodily injury or a property damage in that aspect, but you still have coverage. what I'm trying to say is, if it just says environmental coverage, that's good if you're buying that policy, but make sure it covers what you need it for, and get an opinion up front. Make sure the insurance company is clear what you want it for, and they tell you, you're told it's covered. And this is not a solicitation, but you should have somebody review it, an attorney, etc., and put them on the line to make sure you're covered, because nothing's worse than paying for something and then finding out later it doesn't cover what you need. Okay? The last bullet point, there are companies out there that have offered this for years, and there are some new companies in the arena. Check with that company's experience in defending these cases. How have they handled experts, etc.? I know I'm going into a lot of detail here, and you can usually tell when I give a talk and I get into detail, it means that this has come up. This has been an issue for some of the people I represent. So that's why I'm talking about it. If you haven't had to deal with it, I'm sure I'm starting to bore you. But please, if you need this coverage and you want to talk about this, again, I'm not selling it, but I just want you to, nothing's worse than paying for something and then realizing later it didn't cover what you thought it would. Okay? All right. Another protection for producer. Right to farm laws, they're called. In Iowa, we have the Animal Feeding Operations Nuisance Defense. Some years I don't even talk about this. Why? Because in 2004, the Iowa Supreme Court ruled it was unconstitutional in a case because it was, quote unquote, unduly oppressive as to the neighbors. I won't get into the constitutional arguments here, but the hog operation, and this is not new. This was, again, a 2004 case, so over 10 years old. But the hog operation was 1,300 feet north of a neighbor who had lived there for 22 years before the operation was built in 1996. This is the Gakey versus Pork Extra case. We've talked about it much in years past. We're seeing some, again, let me move to the next slide. As you'll see from this, and I talked about last year, we're seeing some more activity in nuisance cases being filed. We have had several filed in the last year since we talked. And so what I'm trying to say is I and other attorneys are taking another look at that nuisance defense and seeing if some of these cases that are being filed are not unduly oppressive because of the facts. 1,300 feet north of a neighbor that had been there for 22 years. What if the operation's been there for a year or two and it's 3-4 miles away? Now, if you're sitting there thinking, holy smokes, 3-4 miles away, that's an extreme situation to have someone suing you that far away. I think you got a pretty good case if that's the situation. But mile away, half mile away, I think we all need to take a look at those facts to see how that nuisance defense possibly applies. And we attorneys who handle these cases always raise that to see if it can help producers. All right, slide 6. Pardon me. Last year I stood here and said no ag nuisance cases have went to trial since 2008. All right. Last year, none went to trial these are ag nuisance cases, either hog, cattle, or even crop operations that I know of. Now, sometimes people don't call and tell me about these things, but it's my job on behalf of the Iowa Pork Producers Association to try and stay on top of this. To my knowledge, none went to trial. But look, and so that means 09, 10, 11, 12, 13, and 14, none went to trial. Doesn't mean some weren't filed. They've been filed in those years, and they either settle out of court, some were dismissed, etc., but none made it to trial. Well, guess what? Powesheik County, right now, there's a nuisance case going on as we speak. Trial started on Monday. It's against a hog operation, and I'm obviously not involved, or I wouldn't be standing here, but I know the attorneys who are defending that case. I'll keep you posted. Again, it's going on right now. So can't say none have went to trial in 2015. We have one going on right now. Other cases that have been filed, Wapello County, there's a case with a large number of people involved suing the hog operations. There's 3 different producers involved. The court has split it into divisions. I won't get into all the legal nuances. Buchanan County, we have a cattle feed yard that was sued this past year. Trial is scheduled, I think, for sometime July, I believe. Poweshiek County, another swine finishing operation, was sued in May, and that case has not been exactly set for trial yet. And then we have one in federal court, Southeast Iowa. The reason it's in federal court is the people who are suing have moved to another state, and therefore we have what we attorneys in the law calls diversity jurisdiction, so it can be in federal court. That case was filed in August. Okay? Now there have been, yes, ma'am. The question was, what are the facts in the Poweshiek County case that is at jury trial right now? I'm a little sketchy, so I'll be careful what I say, but it's one operation. I don't know the exact size of it, and I believe there are maybe less than half a dozen people suing, something like that. Don't hold me to that. I don't have a lot of facts on the case, but it is a deep pit hog operation with not the large number of neighbors suing like we see in some other cases. Okay? And if you like more information, let me know and we can get it. But I just, that's basically what's going on there. Any other questions? Okay. Now I'm moving into DNR regulation. Anything more about nuisance? I know I've spent a fair amount of time on it, but the kind of thing, like I tell clients who have to call me about this, I wish you hadn't had to call, but you can defend yourself, etc. I won't go back over everything I've talked about. I will, just for a second, Iowa law requires that before a nuisance case against an agricultural operation, before it's filed in district court, it has to go through mediation, through the Iowa Mediation Service. So there are we've had several mediations going on this year that have occurred, and there's a fairly good-sized one that you may be hearing about out of Adair County. There's one in Lynn County. There's one in Davis County, where mediation either is scheduled or has been held, and Iowa law requires that before the people who want to sue can file their lawsuit, they have to offer mediation to those people they want to sue. And where you go to the mediation service, they provide a mediator, and you sit down and hopefully work out your differences. Maybe not successful in many cases in the aspect that the case goes away. Sometimes they do. But more importantly, I think it is a valuable process in that it gets everybody to the table at least once prior to getting the attorneys in full gear in a lawsuit. It gets you to sit down, look at each other, talk about it. Again, not very often do the neighbors walk out there and say, "Gosh, you're right, I was wrong, it's not a problem." But at least it gets you to sit down at the table with them. I always advise producers to go through mediation if possible, and that I think it may not pay immediate dividends, but it is a process that I believe is well worth it. Okay, slide 7. First thing I want to talk about in DNR regulation is calculating animal capacity. I've talked about this before. This was the subject, a lot of what I talked about at the regional seminars for Iowa pork producers last summer. And so the next few slides were on page 2, and the next few slides, most of page 2 covers this. And here's what we're talking about. You either have animal weight capacity or animal unit capacity. I'm going to focus on animal unit capacity. If you have an operation that is still under animal weight capacity, let's talk, because that's a detailed conversation in itself. And I'm not saying it's not important, but since 2003, the legislation adopted in 2002, we've been under animal unit capacity. What is animal unit capacity? A lot of you know this. For swine, it's 0.4 if the swine weigh more than 55 pounds. For swine weighing less than 55 pounds on that site, it's 0.1. All right? And it's a one-time capacity. Okay? It's not the number that goes through in a year. It's your one-time capacity. What is the The maximum number of animals maintained at any one time in a confinement operation multiplied by that factor. Notice I said the maximum that will be confined. It's not the square footage of the building that and how many could be put in there. It's a maximum number you will put in there at any one time. So it's your capacity. It's what you say it is, but you have to follow that capacity. If you exceed that, if it's a certain number head building and then you put more in it, your capacity is now the I put more in it. It's not what you started with, okay? And we'll talk about that. Example, 2,400 head wean to finish site, 960 animal units using the 0.4 factor when they're over 55 pounds, but they're in there at the nursery phase under 55 pounds if it's wean to finish site, so at that stage it's 480. However, since they're on site when they're over 55 pounds, your animal unit capacity is 960, all right? What about if you double stock, triple stock, or any type of overstocking? You can do that as long as you don't exceed your capacity. If it's a 2,400 wean to finish site and you double stock up to 55 pounds, then you're fine because you double stocked as my example. Let's see, let me go back here and then we'll come to this slide. Again, you can double stock because you get to use the 0.1 factor up to that weight. Now, before I get to that, the question I just said up to 55 pounds, and the reason I put this slide ahead of the other one is because the question I get, does it mean before any pig in there hits 55 pounds? Does it mean the average? None of those. What it says, and here's this slide 10 is, I think, a very important slide. It's neither of those because animal units are calculated based on the number of pigs weighing more than 55 pounds and the number weighing 55 pounds or less. Once that pig hits 55 pounds, the way the law reads, that pig could weigh 200 pounds. It still gets the 0.4 factor. Same way being under 55 pounds. Has the same factor till that's triggered. So if you have a pig that goes over 55 pounds, it's the number of pigs over 55 pounds, not an average, not just because one pig's over 55 pounds. And I know all of you know the minute that pig hits 55 pounds, right? All right. Now, I will give you the safest approach first. To ensure compliance would be to remove any overstocked pigs before any reach 55 pounds. If you want to be able to say, I'm in full compliance, I don't have to worry. The minute the day you walk out there and you see that first pig over 55 pounds, get the overstocks out. Then you are absolutely in compliance. Not very workable, is it? All right, how do we calculate this? And again, I'll just kind of cut to the chase here. I think slide 11, circle that if this is an area you need to look into further. It's the number over and the number under. There is a calculation here. I've done it. I've had people check my numbers. Be careful when an attorney does numbers. And what it works out to is if you're double stocking, you have as you can see here, no more than, in a 2,400 head building, no more than 1,600 can weigh 55 pounds before the double stock have to get out. It works out to a factor of 0.3. If you're triple stocking, the factor is 0.1. And I've had people, I think some producers are using spreadsheets here. But the real point is, you can have some pigs. If DNR comes out and says, do you have any pigs in there weighing more than 55 pounds and are you you're double stocking or overstocking, and you say yes, and they say, and I don't think they would, but they say you're out of compliance, you say no, I'm not, because that number, I'm still under my animal unit capacity because I can have this many pigs over 55 pounds and I'm okay. All right? What are your options? If you are sitting here now or listening to me on the internet and you determine that, wait a minute, I might be exceeding that animal unit capacity. Here's one thing I can assure you. If you have all of your pigs, if you're double stocking or overstocking and they're all over 55 pounds, I can't do any calculation for you that shows you're still in compliance. You're out of compliance, or you will be. All right? So, What are your options? Other than one is to reduce your capacities that you're putting in those buildings to comply with what's in your MMP or your permit. Sometimes that's not a good option. The other options are if you built below 500 animal units capacity and now you want to stock more than 500 animal units capacity but less than 1,000, so you're in that MMP CDS range there, I call it. You need to get an MMP and a CDS and go through the process with DNR. If you build above 500, that one is if you were below 500, now you want to be in that category. If you're already in the 500 to 1,000 and want to go above 1,000, you must then get a construction permit, matrix, etc. You have to go through the process. If you have a construction permit, but you're exceeding your permit capacities that are in your permit, you need to get a new permit that increases your capacities. Those are the options you have, and this is where, next to that slide, if you have questions, feel free to give us a call. I'll be glad to talk with you. But next to slide 12, write slide 37. That's the environmental self-audit. Because if you're doing that right now, exceeding your capacities, this is where the environmental self-audit, where you can, we'll talk about it when we get there, but that's where you can notify DNR that you believe you're out of compliance. You do it the correct way through an environmental self-audit, and that you will get into compliance by using one of these options I just gave, then there will be no penalties. Okay? Page 3. All right. Slide 13, one operation or two. I'm not going to go, I'm going to start to skip. Yes, ma'am. The question was, what are the penalties for noncompliance and how frequently are they enforced? On the capacity issue, DNR has been good to work with. They really want you in compliance. I'm always careful to say this because there's instances out there I'm not aware of. Generally, penalties on any type of violation usually range from, 2,000 to the maximum is 10,000. On this issue, on exceeding capacities, unless there's another issue involved, I've seen it, failure to get a permit or an MMP when you need one and when you're over the capacity. The penalties I've seen have been in the range of $3,000 to $6,000. How often is it enforced? When DNR becomes aware of it, that you need an MMP and you don't have one because of your capacities, they will enforce that. Okay? If you use this self-audit process, then there are no penalties if you then get into compliance. And Gene Tinker isn't here this year, but if Gene were here, he said it in years past, DNR supports this process. They want you in compliance. And if you get into compliance by yourself with the self-audit process without a penalty, that's fine with them if you follow the process correctly, because now you're in compliance, now you're filing your MMP, and you're in the system, and that's what the law intends for you to do. They're not, in my experience, not interested in just trying to collect penalties. Okay? All right. Thank you. One operation or two. Bottom of slide 13, adjacent. Confinement operations. This is the issue. If you have operations you own or manage, if they're within 1,250 feet and the animal unit capacity is less than 1,000, well, I should say you look at the two. Here's the way I do it. Somebody calls and says, do I have one or two operations? Meaning if it's one, I have to add them together. It means I need an MMP, permit, etc. If they're separate, then they're both below the threshold. All right? Whatever that threshold is. So you look at the two operations and I'm talking about under common ownership and management, owned by the same person, managed by the same person. If you add them together and they're less than 1,000, then they have to be at least 1,250 feet apart. Okay, and I just had a discussion with somebody last week who was not aware of that. They thought it was 2,500 feet. But again, you add the capacities together, they're under 1,000 animal units, then it's 1,250 feet. Add them together, and if they're over 1,000, then you have to be 2,500 feet apart. Okay? If you're less than that, they're one operation. They have to be added together again if you own or manage them. Okay? If they're further than that apart, then and they don't You see up there, they don't utilize a common area system for manure application, then they're separate operations. This is a big issue for producers adding buildings, et cetera. We could spend a lot of time talking about this too, but if you have questions, what is common ownership? And, is it the son has a building, father has a building? Okay, as long as it's not a dependent son. If it's a son over the age of dependency or daughter, then of course they are considered separate. But you have to look at management also. Are the two managing their operations separately? We used to have an interpretation by DNR that if you were feeding pigs for the same owner, contract feeding, that made you common management. As of 2010, DNR eliminated that rule, so now you can have two people feeding pigs for the same owner. That doesn't make them common management. That's not one of the factors used. The common management is significant control over the day-to-day operations of the site, and that tells you exactly what you need to know, right? All right. Again, I don't mean to gloss over this. There are a lot of nuances here. Here's what I will say. If you're looking at splitting, ownership, it's an issue that DNR looks at closely, and I would just urge you to think about the long term. Is it really worth splitting that ownership up when those buildings are going to be there a long time? And is it avoiding an MMP or a construction design statement, et cetera, separation distance? Is it really worth that, or would it be? Here's what I have said before: don't let the DNR tail wag the dog, because I know you have to live with those operations for a long time, and those management decisions that you make, take a look at the big picture and decide if it's really worth working on splitting up ownership, et cetera. I know I kind of danced around that a little bit, so feel free to talk to me about it. Slide 14 is another separation distance used for adjacency for separation distances to the neighbors. I won't get into that because we'd be here another half an hour. All right, slide 15. Now I want to get into, I'm going to skip through these fairly quickly because I want to get to the work plan and some of the other things, and we have about a half an hour left, and I think we're pretty much on target. Confinement operation is where they're totally roofed. We have the 10% issue outside, more of an issue for cattle buildings. Now we're talking mainly federal regulation as enforced by DNR, whether you need a discharge permit. We'll, bottom of slide 16, CAFO discharge, you're a CAFO and you have to have a discharge permit if you discharge pollutants to a water of the U.S. Without an NPDES permit, you cannot discharge. With an NPDES permit, you can if you're designed for the 25-year, 24-hour storm. But, and large CAFOs, anything over 1,000 animal units. Medium CAFOs we don't deal with much in hogs as we do cattle operations. Here's where I stop. This is my public service announcement, and then DNR's in full agreement with me here, and I think EPA is to an extent. I'm kind of going off script here. NPDES permits, the DNR work plan. EPA is requiring DNR to go out and do inspections to determine if these operations are discharging. But wait a minute. You're going to see in a slide, and I've said it many times, under Iowa law, confinement operations can't discharge. If you have an NPDES permit for a confinement operation, which there are none in the state of Iowa that I know of, that NPDES permit would say you can't discharge. So it's a discharge permit that says you can't discharge because state law won't let you discharge. That's why we've never had to have them, folks, because Iowa law is stricter than federal law for confinement operations. Confinement operations where the animals are totally roofed. So that's why I'm going to skip through these slides. While it's a major point of the work plan and the inspections, your operations can't discharge, period. And those of you that have been through these work plan inspections are well aware DNR is coming out and taking a look. They need to look in addition to the confinement buildings, they have to look at your feed storage and also your mortality, the composting. And now composting can't discharge either, and that's why I want to talk about that in a minute. All right. I don't mean to confuse things here, but by skipping over some slides, but I think that's an important issue to at least have the foundation of. All right, slide 21. If you have a confinement and an open feedlot on the same site, within 1,250 feet of each other, draw a circle around this. Okay, this is a major issue that EPA is going after as well as DNR. If on that site you have, here's my example, hogs with more in confinement with more than 2,500 head, a 3,000 head finisher on site, and you have a cattle feed yard, say less than 1,000. I'll go ahead and say it. Folks, you have a target on you right now, and you need to be aware of that, and I'll be glad to talk to you. You are one of those operations that EPA and DNR believe probably may or may not be aware that because that cattle feed yard is less than 1,000, you may think that you don't need an NPDES permit or at least have to worry about discharges as a large CAFO because it's less than 1,000. But if they were both below the 1,000 animal units, if hogs were less than 2,500 head and the cattle were less than 1,000, you wouldn't add them together under federal law and as the state enforces it. But if one triggers it, the 3,000 head of hogs, then everything on that site gets pulled in as to whether you need an NPDES permit. Well, the hogs, you're not going to discharge from that. It's a confinement building. They're not worried about looking at that. But that cattle yard of 300 head, whatever number of head it is, that's the focus. And they're doing the flyovers. I have a slide on that. EPA is, DNR doesn't do them that I know of. And they're looking for those hog buildings with an open lot outside. And they will come and do an inspection. And if that small open feedlot, less than 1,000, is discharging or they believe it's discharging, you're going to be the subject of an enforcement action, and they're going to tell you you need an NPDES permit or you need to stop discharging. If you have this situation, please take a look at it, get some help with a consultant, etc., to make sure you're in compliance before they come to do the inspection. Okay? Designating CAFOs, slide 22, 23, 24, I'm going to skip over that. Not that it's not important, but if you're having discharge issues from, say, a cattle yard or a hogs in open lots, DNR can, no matter your numbers, can designate you a CAFO. Then we come to slide 25, application, land application, manure application. If you're applying based on your MMP, then you have what's called, if you don't apply at more than those levels, you have what's called the ag stormwater exemption. If there's a precipitation event that causes a discharge, then that would not cause you to need an NPDES permit. Now, you'll still have DNR to deal with if you have a discharge and causes a water quality violation. Accidental discharges, hose breaks, slide 26. Again, you'll have DNR to deal with if you cause a water quality violation, but if it's an accidental discharge and you correct the problem, then you won't need an NPDES permit. Don't let anyone tell you differently, okay? Slide 27, I've talked about proof of a discharge. Again, I want to get through these slides and we're now to the work plan, slide 28. I could ask you how many have been through a work plan inspection, and I think I will. How many here have been through a work plan inspection? All right? I think generally from what I hear, and you know, I'm an attorney. Nobody calls me to tell me things are going fine. My phone doesn't ring off the hook with problems, and so I think generally the inspections are going well. There's some glitches here and there. I'm not going to talk about as part of the work plan, there were some rules adopted. I'll get to the inspections in a minute. There were rules adopted this past year on confinements getting NPDES permits. But McAfee, didn't you just say they can't discharge, so why would they need an NPDES permit? Why did we do the rules? Because EPA said we needed the rules. We did the rules. I don't hope we never use them. They just incorporated federal rules. Okay. Setbacks on manure application, slide 28, third bullet point down, put a check there. Setbacks for manure application, unless you have an NPDES permit, which I've just said no confinements have, setbacks did not change. Had a lot of concern about the way the rule was worded, but no, it just incorporated federal law setback if you have an NPDES permit. Confinements that don't have an NPDES permit, nothing changed. You don't need to worry about it, okay? Inspections. And I'm going to, again, move through these fairly quickly. DNR must do desktop assessments first, take a look at what's publicly available, and before coming out to do an inspection. Here's the priorities, slide 30. First, they were to do assessments for those with spills or releases, then the large open feedlot CAFOs over 1,000, and then the medium-sized open feedlot animal feeding operations. The fourth category down were the large CAFO confinements, and the last category are the medium-sized, the under 1,000 CAFO confinements. Now, I'm sure some of you sitting out there can say, wait a minute, I know of a medium, a 2,400 head site that has been inspected. DNR will take them out of order in the interest of efficiency, etc., but generally this is the priority they are following, and I know in some field offices they are already through the first category and maybe even close to getting through the second category. They are to have this done within 5 years. And I believe generally they're on track. Slide 31, if they're doing an large, anything over 1,000 animal units, which is 2,500 head for hogs, they will be there. They will do it on-site at some point. Even they'll do the desktop first, but they will do it on-site. The medium size, they may or may not. Okay? Again, I know I'm moving over some things, but I think a lot of you have covered this. If I skip over something you want to talk about, please stop me. All right, the slide 32, the discharges. This is when they determine on the medium size if they're going to come out and do an inspection. Again, on slide 33, the combination operation and the medium-sized open feedlots. If there's been an accidental discharge, you're in the top category, but again, I talked about no NPDES is required if you've corrected that condition. We're on slide 35 now. All right, what happens when DNR calls and says we're coming to do an on-site inspection? They are to give you 1 to 3 days before the inspection. My experience is they'll give you some more time than that. Is that generally yours? About a week, somewhere in there. What should the producer, what do they expect you to have? They want you to have your MMP and other facility records available. Put a check mark if you're keeping score here. DNR will not enter confinement buildings. I know of no instance where they've done that. If you know of one, tell me, because they are not, and I repeat, are not to go into confinement buildings. There is no reason for them to do that. The state office and the field offices are aware of that. They are not to go in your buildings. And they must follow your standard biosecurity policy. If you don't have one, they will follow theirs. And many of you have heard me say before, your standard biosecurity policy cannot be that DNR is not allowed on my operation, okay? Some have tried. No, I'm kidding. Anyway, all right. Here's where we're getting close to that slide about environmental self-audits. What I have seen thus far, and I'll talk about what they're going to look at, but what I have seen thus far, for confinement operations, we aren't going to have too many problems with discharging. You can't. Now, you need to make sure your operation is clean and all that, which is important. But what I'm seeing happen more than that, and maybe some of you can tell me, when DNR is out there to do this inspection, they're going to look at other things related to your other regulations you need to be in compliance with. I know one example is a producer who had added on to the farrowing building, didn't increase capacity as far as the number of sows, but added crates. Well, the producer didn't think they needed a permit. But they did, and I won't go into the details why they did. DNR was there, noticed that the building had been added onto, said, did you get a new permit? No. There turned out to be no penalty there, but there could have been. Here's my point. Okay, the last bullet point there. 2 bullet points. Conduct a complete environmental review, do a self-audit with your consultant advisor. Oh my gosh, attorney, how about that? We do a review, try and make sure that before DNR gets there, just have somebody go through the regulations with you to see, am I in full compliance? If I'm not, then do an environmental self-audit. You can say, I've discovered during this self-audit that I have a violation. That's one. First of all, you send DNR a piece of paper that says, by certified mail, I'm doing a self-audit. Second piece of paper says, during this self-audit, I discovered a violation. That's what's in this handout up here, what needs to be in those notices. If you do it that way, there will be no penalty. If you, and DNR, again, has been very good through this process. They are encouraged to get people into compliance, okay? So, I think, to me, that's one of the major issues we're seeing in these inspections. Make sure you're in compliance with all the regulations, okay? When you're notified of an inspection, what should the producer do? I suggest you ask for a copy of the desktop assessment, which they've done, and they will send it to you. Just see what they found in that desktop assessment. Ask them whether they've already been there since November 1 of 2011, and that inspection could apply to this one, so they don't have to come back out, and inform them of your biosecurity policy. And many, and I know there are consultants here who will be contacted by producers when they get the notice from DNR, and often your consultant will be there with you during the inspection. During the inspections, DNR is to review the records they've asked you to have available. They are to, and this is what the work plan says, ask about the maximum number of head confined at any one time over the last 12 months. That's where that animal unit calculation comes in. If you have an issue there, as we talked about, address it now, not after DNR is there, okay? During the inspection, they'll look at manure storage structures, they'll look at manure stockpiles. If you're a dry manure operation, if your perimeter tile that you have to have at most confinement buildings, they'll check that. Your inspection port or outlet, have had a few issues come up with that on some of the work plan inspections. Feed storage. You know that little pile of feed you get under a feed auger? Is that going to get into a water of the state and be a discharge that would require an NPDES permit? Heavens no. We know that. But before DNR comes, scoop it up. Clean it up. And you should do that regularly. But before the inspection, just kind of look at those things, because DNR will likely have a recommendation that you had some spilled feed on the bin pad and it should be cleaned up, okay? And I know many of you do that as a matter of course regularly, okay? Mortality handling, composting. Let me stop here a second and go off script. In this handout up here, there is some confusion out there at times about if you use rendering, the law used to say you had to have that animal properly disposed of by rendering, meaning picked up, within 24 hours. We all know that no rendering company anymore comes every day. The law says, as of, I think, 3-4 years ago, it was changed. For rendering, you are to have that dead animal disposed of within a reasonable time. So it's not 24 hours. You should get it in the dead box, in the dead area, etc., properly waiting for the rendering truck, but it is not required that the renderer get there within 24 hours. If they can, great, depending on the time of year, etc. Now, composting, the law does say you're to have that mortality in the compost pile within 24 hours. Okay? I just wanted to clarify that. Again, that's in our handout here. One thing, the last point there, photos. Have gotten calls from producers that said, my gosh, they took a lot of photos. Does that mean I have a problem? I was concerned about it. And those of you that have been through inspections can tell me if I'm wrong. But what I am understanding from DNR is that one of the criticisms EPA had of them over their inspection process over the last years was they weren't documenting what they found. And they weren't documenting that there was no discharge occurring. Well, I could have told EPA, I got news for you. If there were a discharge occurring, pretty sure DNR would have written it down. The fact that they didn't write anything down or take a picture should tell you there was no discharge occurring. But what EPA wants is more documentation. So what I'm hearing and finding is that a lot of photos will be taken to show documentation. That doesn't mean you have a problem. It means DNR is documenting the file. I assume that's what many of you are seeing also. Okay. You should get a report within 2 weeks. We're on slide 40. the reports I've seen, I'm not sure you'll get it within 2 weeks, but they're busy like the rest of us. It'll have a section on recommendations and a section on any requirements if you need to do something different. The recommendations section is intended by DNR to tell you, why don't you take a look at doing this? It's a recommendation that may keep you out of the second section, which are the requirements. Okay? That's it on inspections. Anybody questions or any comments about inspections? Okay, slide 41. DNR has been told by EPA as part of the work plan they are to create a stronger deterrence through penalties to noncompliance. To me, what this means, folks, is penalties aren't going down. Those numbers, if you hear somebody say 5 years ago I was penalized X for what happened, that number you're looking at, if you unfortunately have a violation, is not going to be lower. I haven't seen them go up a great amount. I think DNR is, in my opinion, doing a good job of looking at the factors, et cetera, in most cases. But they have a checklist developed now for enforcement actions. I hope you never have to look at that, but if you do, let us know. All of this stuff is online. I think I had the Google search term in the earlier slide. DNR, slide 42, is to provide progress updates. And they are doing that. If you want to take a look at those, they are online. Okay, let me get caught up here. We're on slide 43, which is top of page 8. Composting. I've mentioned it. I've talked about it. Here are some slides about it. These generally lay out the requirements that are also in the handout I have. If you're composting, take another look at these. Make sure you're meeting these requirements. These are DNR requirements. Let's see, where's the looking for the bulking agent one. All right, slide 46. To control leachate odors and animal scavenging, you must have 12-inch bulking agent cover, 6 to 12 inches between carcasses, and 12 to 24-inch base, depending on the size and number. That's the bulking agent, sawdust, whatever you're using. Now, I would say this if Gene were sitting here, but I'll say this with a smile on my face. I think when DNR comes to do your inspection, you should ask them to check that 6 to 12 inches between carcasses to see if you're meeting that. Now, if they ask you to do it, I'd say, oh, I'm pretty sure we've got it covered. But anyway, go ahead, sir. Another comment with a smile on the gentleman just said he's been composting for 10 years, and coyotes don't bring a tape measure. In other words, you're saying they don't, if you've got more than 12 inches, they don't run the other way, right? If you don't have 12 inches, then yes, there is. Other ways to handle animal scavenging, and we all want to take a look at that. I got to tell you another story. I think I'm okay on time, but I work with a gentleman from Illinois. Illinois has, he's an expert there, works with the Illinois pork producers. And I think Illinois, don't quote me on any of this if you're in Illinois, but has something like, a separation distance even. And we have them for, as well from the neighbors. And he said the point they make about scavenging and the separation distance from the neighbor is it's intended to give you enough room to draw a good bead on the neighbor's dog as they leave your... Now, I would never say something like that, but that's what they said. Okay. I'm sure he will give me a hard time when he sees this on the internet. Okay. Anything else? Any other questions on composting? Again, keeping scavengers out is an issue. If you're the subject or have concern about a nuisance lawsuit, you will hear, what do you do to keep birds and other, eagles that we have in Iowa now that, some of you cover your compost piles, some don't. If you cover it, then you have to deal with adding water to it at times. If you don't cover it, then you have to make sure you control the leachate, have no runoff. Composting is an art in itself, and I know many of you do it. I'm not going to stand up here and tell you how to do it. If you have questions, there are a lot of experts out there who can help you with it. But these are the DNR regulations that DNR will take a look at when they come out. Okay? All right. Master matrix, if you're, these slides just cover some of the issues that we see in getting your master matrix points. I'm probably going to leave that alone unless you have some questions. Here's my try and stay away from a gotcha slide. Many of you have seen this before. Open burning, slide 49. If you have, and I put it in quotes, burn barrels, I don't care what it is you're burning, Iowa law says you can't open burn combustible materials unless variants, okay, never mind. Exemptions include trees, recreational fires, residential waste. You can burn from household waste, okay? And then paper or plastic, pesticide, and seed corn bags gives you the distance. Notice you don't see feed bags there. Don't ask me why. All right. Here's what will happen in a DNR inspection. If they see a burn barrel or burn area around your hog building, and if your house is there, you will say, but that's residential waste. And I could give you examples, but you know better than I. You better hope in that burn pile there is nothing that, like a Tylenol bottle or something that didn't come from your house, okay? Because I've seen producers getting written up for this. If your hog building is not anywhere near your house, you're going to have to convince DNR that you bring your household trash over there to burn, and that might be a difficult argument to make. This is just one of those gotchas, okay? EPA air emissions reporting. Gosh, how many years ago was it? That was a major topic here at the Pork Congress about the qualifying releases. We all remember the reports we filed for a few years there, et cetera. They still need to be filed if you build a new operation. Let me know if you have any questions about that. And manure application on frozen or snow-covered ground. Again, earlier this year, with the kind of fall we were having, this was probably going to be a big topic. In many areas of the state, it turned around for us. Manure, we were able to get you were able to get the manure out. I don't think we ran into a lot of issues there. Then we did get a cold snap early there around Thanksgiving, if I remember right, so it was froze up. But that was before the dates that kick in here. So right now, what is it supposed to be, in the low 50s here in most areas of the state today? So here's what I'll say about all of these. First of all, I'll kind of quit talking generalities and get to the point. Slide 53. It doesn't apply to open feedlot operations, doesn't apply to dry manure. It's for liquid manure from confinement operations or it doesn't apply to the SAFOs, less than 500 animal units, and it doesn't apply if you inject or incorporate on the same day. So what does the prohibition apply to? You can't surface apply from a confinement operation between December 21 and April 1 if the ground is snow covered. Snow covered is more than 2 inches of, more than an inch of snow or a half inch of ice. Then from February 1 to April 1, you can't do it if it's frozen, and that's frozen in the top 2 inches or more. I've got it worded the other way there for the doesn't apply. If you have to do it during those dates when those conditions apply, then you need to show DNR it was an emergency. Had a water line break, something like that. But right now, we are past the date for snow covered, right? But if you don't have a snow cover, you can go ahead and apply. The dates don't matter if you don't have the conditions like snow covered or frozen. Likewise, when we had that ground freeze up around Thanksgiving, well, it wasn't February 1 yet, and it's not February 1 even now, obviously, so you could still apply even though it's frozen because we haven't hit the date yet. So you got to have both. You got to have be within the dates and those conditions apply. If you don't have both of them, then you're not subject to these restrictions. There's what an emergency is. I'm on slide 57. Here's what you need to do to contact DNR. I'll let you take a look at that. Okay, here's the slide I told you about. We've got about 5 minutes left since we started 5 minutes late. I'm on page 10. It says slide 4. The computer balked at me here. It should be slide 59. 60-day notice of intent to sue filed by the Des Moines Water Works. Again, we talked about it briefly. This is not an issue directly I don't believe, for Iowa pork producers, and I say directly. Why? Because I'm not saying it's not an issue, and we should all be concerned. We're all farmers. We're related to farming, and this is a very important issue to Iowa agriculture. But folks, you're the ones that I just said, your operations are no discharge. You can't under Iowa law, okay, from the confinement operation itself. So no discharge. Number two, what does your manure management plan say? Your manure management plan says you have to apply based on crop uptake, nitrogen crop uptake, okay? So whatever the crop uses, that's what you get to apply, not just manure, but any other fertilizer that you put on along with that manure on those acres, okay? So you're subject to crop uptake, all right, as a confinement operation with a manure management plan. Some of you are under all of you have to do a phosphorus index. If you're under the phosphorus index restrictions, they're even tighter. My point here is, folks, confinement operations in the state of Iowa are subject to extensive regulation now, and I know you have other farming operations, you have maybe other livestock operations, but your confinement hog operations should not be the target here. We've got the regulations that require us to have no discharge. Now, do accidents occur? We all know they do. When an accident occurs, it's taken care of. DNR will require compliance and most likely a penalty. But don't let anyone tell you that your operation is I'm choosing my words carefully, because we're all in this together as agriculture, but don't let anyone tell you that the confinement operations are the ones that the notice of intent to sue is pointed at, okay? The press may say that, but that's not where we're at, okay? More about the notice of intent to sue. Here's what the Des Moines Water Works is alleging. They sent a notice to 10 drainage districts in Buena Vista, Sac, and Calhoun counties. Any of you here in a drainage district? All right. If you're not, they're kind of a different breed of cat, so to speak, but they were established years and years ago to bring people together who need a common source of drainage to establish, tile lines and county tile lines then, and county drainage ditches, people call them, so they can, many areas of the state, you don't have to worry about this, but they need this cooperative effort to drain the ground so they can farm it. Done many years ago, and these are associations, and I've given this talk several times. You talk to anybody in a drainage district association, it's not like they get together monthly and talk about, hey, what are we all doing out here? The only time you really hear about it is when there needs to be an assessment levied so they can fix the tile line, put in new tile. That's when you hear from them, when there's a levy. And again, they're very important to the farmers that are in them, but these aren't well-organized groups that get together all the time as maybe this notice of intent would have you believe. The notice of intent pretty much says these are engineered uniform drainage systems that are the equivalent of a point source under the Clean Water Act. What's a point source under the Clean Water Act? Large CAFOs are by law a point source. Farm field tile line, well, what else are point sources? Manufacturing, Des Moines Water Works is a point source, and they have an NPDES permit. Other municipalities are the same. What this notice of intent to do strives to do is to equate these drainage districts with that, because they're engineered, organized, etc., they believe they can make the argument that those tile lines coming out of those drainage districts are point sources, and as a point source under the Clean Water Act, then they would be required to have an NPDES permit, which would limit the discharges of pollutants, which the Des Moines Water Works argues are nitrates. What they've done, then, that's the argument they're going to make to the court. Based on my research and others, there's never been a court that has found a tile line in this situation to be a point source. So this will require a court to take the law several steps further. But a citizen suit is when essentially under the Clean Water Act, who enforces the Clean Water Act? That's usually EPA and DNR, if they believe somebody's in violation of the Clean Water Act. If they are not enforcing it in this situation, which they aren't, then a citizen can step in and file a lawsuit, which is what the Des Moines Water Works has done. But before they can do that, and in essence, they're stepping into the shoes of the government and saying, we're going to enforce the Clean Water Act by suing these drainage districts for violating it, even though DNR and EPA isn't. And the Clean Water Act has a provision for that that requires them to give a 60-day notice before they do that. That's what we have. That's what the Des Moines Water Works has done as of January 9th. Once the 60 days are up, then the Des Moines Water Works will legally be allowed to file suit against these drainage districts. And it will be filed in Federal District Court, Northern District of Iowa, where they're located. I guess all I can say is stay tuned. The Iowa Pork Producers Association, this is not a public service announcement, but the Iowa Pork Producers Association, along with many other associations, are keeping a close eye on this, has been proactive, as you know, and along with a lot of others in agriculture with the nutrient reduction strategy, with formation of alliances, the Iowa Ag Water Alliance, to work cooperatively. This suit is a different approach. I'll leave it at that. And again, I want you to know agriculture is actively involved in responding to this in support of the drainage district.